That's Chief Justice John Roberts, writing for the majority in Students for Fair Admissions versus Harvard. Sounds simple, right? Almost obvious. But Justice Sonia Sotomayor, in her dissent, called that same sentence a distortion of the Constitution's guarantee of equal protection. Same words, same Constitution, opposite conclusions. One side says the decision finally delivers on the promise of colorblind equality. The other side says it guts 50 years of progress toward racial justice. They can't both be right, or can they? If you listen to the previous episode, Two Americas, you understand what's underneath this case. If you haven't, I recommend going back. But if you want to dive straight in, you can. I'll give you what you need. 2 episodes ago, I promised to show you how to read a Supreme Court opinion for yourself. Today, I'm keeping that promise. We're going to take this case, one of the most controversial decisions in a generation, and read it together. Not a summary, not talking points, the actual opinion. But we're going to do more than that. We're going to ask the questions the court didn't answer. Questions about merit, about history, about who gets to forget the past and who is trapped by it. By the end of this episode, you won't need me to tell you who's right. You'll be able to decide for yourself. I'm Mucho Belinda, and this is the third voice. Before we read the opinion, you need to understand what happened. Let me give you the facts. Harvard University, like many selective colleges, considered race as one factor in admissions. They'd been doing this for decades, since the Supreme Court said they could in a 1978 case called Regents of the University of California versus Bay. The goal, Harvard said, was diversity. They wanted classrooms with students from different backgrounds, different perspectives, different life experiences. They believed this made education better for everyone. An organization called Students for Fair Admissions disagreed. They argued that Harvard's admissions process discriminated against Asian American applicants, that equally qualified Asian American students were rejected while less qualified students of other races were admitted. They sued. The legal question was this: does Harvard's race-conscious admissions program violate the Equal Protection Clause of the 14th Amendment? Let me translate that. The 14th Amendment says no state shall deny to any person within its jurisdiction the equal protection of the laws. That means the government can treat people differently based on race, unless it has a really, really good reason. The legal term for really, really good reason is compelling interest. And even if there is a compelling interest, the government has to use the least intrusive means possible. That's called narrow tailoring. So the court had to answer, is diversity in education a compelling interest? And if so, was Harvard's program narrowly tailored to achieve it? For 50 years, the answer had been yes. In 2023, it became no. Let's read why. Before we dive into this specific case, let me teach you the structure. Every Supreme Court opinion has the same basic parts. Once you know them, you can read any opinion. Part 1, the syllabus. This is a summary at the beginning. It's written by the court staff, not the justices. It's helpful, but it's not the actual opinion. Lawyers don't cite the syllabus, neither should you. Part 2, the majority opinion. This is the official decision, It's the law. When people say the court held, they mean what's in the majority opinion. It usually starts with the facts, then explains the legal question, then walks through the reasoning, then announces the holding, the actual decision. Part 3. Concurrences. Sometimes the justice agrees with the outcome, but wants to add their own reasoning. That's a concurrence. It's not the law, but it can signal where the court might go in the future. Part 4. Dissents. Justices who disagree write dissents. Dissents aren't the law, but they matter. They show the arguments the majority had to overcome. They sometimes become majority opinions decades later. Justice Harlan's dissent in Plessy v. Ferguson, arguing against separate but equal, eventually became the foundation for Brown v. Board of Education. And they reveal what's actually at stake in a case. Because dissenting justices don't have to be diplomatic. They can say what they really think. Here's the key insight. The majority tells you what the court decided. The dissent tells you what the court chose not to decide and why that choice matters. Read both, always. Now let's apply this. Chief Justice John Roberts wrote the majority opinion, joined by Justices Thomas, Alito, Kavanaugh, and Barrett. 6 justices, a clear majority. Let's read it. Roberts begins by framing the question. He writes, "The student must be treated based on his or her experiences as an individual, not on the basis of race." Notice what he's doing. He's establishing a principle before he gets to the analysis. The principle is individuals, not groups. He continues, "Many universities have for too long done just the opposite." That's not legal analysis. That's a value statement. Roberts is signaling where this opinion is going. Now he gets to the legal framework. He explains that any government use of race must satisfy strict scrutiny, the most demanding legal test. He writes, "Strict scrutiny requires that race-based government action serve a compelling interest and that such action be narrowly tailored to achieve that interest." Let me translate. Compelling interests means the government's reason must be extremely important, not just nice to have. Narrowly tailored means the government must use race as little as possible and only in ways directly connected to the goal. This is the test Harvard had to pass, and Roberts is about to explain why they failed. He identifies several problems. Problem 1. The goals are too vague. Harvard said it wanted diversity to promote training future leaders, preparing graduates to adapt to an increasingly pluralistic society, and similar goals. Roberts writes, "These are not sufficiently coherent for purposes of strict scrutiny." Translation: if you can't define what you're trying to achieve, you can't prove that using race is necessary to achieve it. Problem 2. No endpoint. Roberts asks, when does race-conscious admissions end? When is diversity achieved? Harvard didn't have an answer. Roberts writes, "The court has permitted race-based admissions only within the confines of narrow restrictions. University programs must have a logical endpoint." This echoes Justice Sandra Day O'Connor's opinion in Grutter v. Bollinger from 2003, where she wrote that she expected race-conscious admissions to be unnecessary in 25 years. It had been 20 years. Robert is saying, time's up. Problem 3. Racial categories are arbitrary. Roberts points out that Harvard uses broad categories, Hispanic, Asian, white, that lump together vastly different groups. He writes, when a university admits students on the basis of race, it engages in the offensive and demeaning assumptions that students of a particular race, because of their race, think alike. This is Roberts' core philosophical argument. Racial categories obscure individual identity rather than reveal it. The holding. After this analysis, Roberts announces the decision. Harvard admissions programs violates the Equal Protection Clause of the 14th Amendment. He adds, eliminating racial discrimination means eliminating all of it. That's the sentence from my cold open. Now you see its context. Roberts is arguing that the Equal Protection Clause requires colorblindness, treating people as individuals, never as members of racial groups, even for benevolent purposes. That's the majority opinion, but it's not the whole story. Justice Clarence Thomas wrote a concurrence. He agreed with Roberts, but wanted to say more. Thomas' concurrence is deeply personal. He writes about his own experience as a black man who attended Yale Law School when affirmative action was new. He writes, I have long believed that the solution to racial discrimination is not more racial discrimination. And later, the Constitution abhors classifications based on race, not only because those classifications can harm favored races or are based on illegitimate motives, but also because every time the government places citizens on racial registers and makes race relevant to the provision of burdens or benefits, it demeans us all. Thomas argues that affirmative action harms the very people it claims to help by creating stigma, by making people wonder whether minority students really earned their place. He writes, affirmative action policies stamp minorities with a badge of inferiority. This is a consequentialist argument, an argument about outcomes, not just principles. Thomas believes, based on his own experience, that race-conscious admissions backfire. You may agree with him. You may think his experience is not universal, but this is his reasoning. And it explains why this isn't a simple left versus right issue. Justice Thomas, a black man, is the court's most forceful voice against affirmative action. Now let's read the other side. Justice Sonia Sotomayor wrote the main dissent, joined by Justices Kagan and Jackson. Sotomayor does not hold back. She begins, the court subverts the constitutional guarantee of equal protection by further entrenching racial inequality in education. Notice the framing. When Roberts says eliminating racial discrimination requires colorblindness, Sotomayor says colorblindness entrenches discrimination. Same words, equal protection, opposite meanings. She continues, the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. Let me translate. Sotomayor is arguing that you can't ignore race in a society built on racial hierarchy. Pretending race doesn't exist doesn't make racism go away. It makes racism invisible and therefore harder to fight. She attacks Roberts' principle directly. The majority's vision of race neutrality will entrench racial segregation in higher education because racial inequality will persist so long as it is ignored. This is the fundamental disagreement. Roberts says, treat everyone as individuals. Stop counting by race. Sotomayor says, treat everyone as individuals, in a society that has never treated everyone as individuals, locks in the advantages of those who already have them. She gets specific. She points to the history of the 14th Amendment itself. The 14th Amendment was shaped by the rise and fall of the Reconstruction era. It was a transformative moment in our nation's history when the Constitution was amended to recognize that Black people are full and equal citizens. Her argument? The 14th Amendment wasn't designed for colorblindness. It was designed to undo white supremacy. You can't do that by pretending race doesn't exist. She then addresses Justice Thomas directly. Justice Thomas ignites too many straw men to list. He speaks only for himself. This is unusual. Justices rarely attack each other by name, but Sotomayor wants to make clear Thomas' experience is not universal Black experience. His rejection of affirmative action does not represent all Black Americans. She concludes with let them eat cake obliviousness. Today, the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in laws does not make it so in life. Let them eat cake obliviousness. That's not legal language, that's a knife. Sotomayor is saying the majority is so privileged, so removed from the reality of racial inequality that they can pretend race doesn't matter, while people on the ground live with the consequences. Justice Ketanji Brown Jackson wrote a separate dissent, focused on history and economics. She argues that you cannot understand present inequality without understanding how it was created. She writes, Gulf-sized race-based gaps exist with respect to the health, wealth, and well-being of American citizens. They were created in the distant past, but have indisputably been passed down to the present day through the generations, and no one benefits from ignorance. Jackson's argument is empirical. She's saying, look at the data. Black families have less wealth, worse health outcomes, lower educational attainment, not because of individual choices, but because of centuries of policy. She writes, Translation: White Americans have benefited from race-conscious policy for 400 years. Now that policies might benefit others, the court calls it unconstitutional. Jackson is naming what she sees as hypocrisy. You've now read the majority opinion and the dissents. But here's what strikes me about this case. Both sides argue philosophy, colorblindness versus race consciousness, principle versus history. But there is an empirical question neither side fully engages. Did it work? The people admitted through affirmative action over 50 years. What happened to them? Did they fail out? Did they struggle professionally? Did they prove the critics right? Or did they graduate, earn advanced degrees, become doctors and lawyers and professors and CEOs? The data exists, and the data says they performed. Studies tracking tens of thousands of students over decades found that those admitted to selective schools through race-conscious programs graduated at comparable rates. They earned advanced degrees. They became leaders in their fields and communities. Black physicians trained at selective medical schools serve communities that would otherwise have no doctors. Lawyers who got their start through these programs sit on federal benches, run major firms, argue before the Supreme Court. Some sit on the Supreme Court. The experiment ran for 50 years. The results are in. The question was never whether they could perform. The question was whether they would be let in the door. And now the court has closed that door, not because the policy failed, but because the principle offends them. That's not an empirical judgment. That's an ideological one. You can agree with it or disagree, but let's be honest about what it is. There is a question beneath this case that almost no one will say out loud. If affirmative action exists because certain groups can compete on merit, doesn't that imply those groups are less capable? And if they still need it after 50 years, doesn't that confirm it? This is the argument Justice Thomas makes explicit. He calls affirmative action a badge of inferiority. He says it creates the very stigma it claims to fight. That beneficiaries spend their careers wondering and being asked whether they truly earned their place. He would rather compete without help and be judged on results. But here's what that argument assumes: that the competition is fair. Is it? Merit in college admissions means test scores shaped by family income, GPAs from schools funded by property taxes in neighborhoods shaped by redlining, extracurricular that require money and time, essays polished by private counselors, legacy preferences for families who could attend when the doors were closed to everyone else. Merit isn't neutral. Merit measures advantages already accumulated. So when we say compete on merit, we're saying compete using the tools you were given, and some people were given more tools. This is a tension the court cannot resolve. Affirmative action may create stigma, but removing it may lock in exclusion. Both harms are real. The question is, which one we're willing to live with? This case was decided in June 2023. Within months, the same logic spread everywhere. DEI, diversity, equity, and inclusion, became a slur. We started hearing, can you trust a pilot hired through DEI? Is your surgeon qualified or a quota fill? Did your colleague earn her promotion or her skin color? The word DEI became shorthand for unqualified. And notice who gets questioned? No one asks whether the legacy admits earned their spot. No one wonders if the donor's daughter is qualified. No one questions whether the CEO's son deserves his corner office. Merit has never been the only criterion in America. Connections, wealth, family, these have always opened doors. But we only started demanding pure meritocracy when the doors opened for others. The suspicion flows one direction. And that tells you something about what this is really about. I'm not saying every DEI program is perfect. I'm not saying standards should be abandoned. I'm saying if we're going to talk about merit, let's talk about all of it. Not just the program designed to include, but the systems that have always excluded. You'll hear people say, the past is the past. We can't keep relitigating history. We have to judge today by today's standards. It sounds reasonable, but watch how selective it applies. We celebrate the Founding Fathers. We revere the Constitution. We honor families' legacies and inherited wealth. We respect old money and elite networks built over generations. The past matters when it's time to collect. But when it's time to account for how that wealth was built, who was excluded, whose labor was stolen, whose land was taken, which laws made accumulation possible for some and criminal for others, suddenly the past doesn't matter anymore. We inherit the achievements, we disown the crimes. We cash the check, we deny the debt. That's not moving forward. That's selective memory. And selective memory has a name: revisionism. If the past truly doesn't matter, Give back the inheritance. Surrender the network. Start from zero like you're asking others to do. But no one does that. Because everyone knows the past matters when it benefits them. The past only stops mattering when it's time to pay what's owed. Now let me turn the lens to the other direction. Because I've seen the past used as a weapon, and I've seen it used as a crutch. I come from Africa. I've heard the argument my whole life. Every problem on the continent is because of the white man. Colonialism, exploitation, extraction, and much of that is true. The borders drawn by Europeans, the resources stolen, the systems designed to extract, not develop. But I've also seen something else. Leaders who blame colonizers while looting their own people. Politicians who cite imperialism while practicing tribalism. Systems where corruption is endemic, not because of the white man, but because of us. At some point, the explanation becomes an excuse, and the excuse becomes a hiding place. History explains. It does not excuse. Yes, the deck was stacked. Yes, the obstacles were real. Yes, systems were designed against you. But the past is a context, not a crutch. And here's what I've learned. Those who deny history and those who hide behind it are doing the same thing. They're avoiding the hard work. Deny the past and you never have to repair it. Hide behind the past and you never have to build despite it. Comfortable. Neither is honest. The truth, the whole truth demands both. Acknowledge what was done and take responsibility for what you do next. That's not a contradiction. That's the only way forward. So what does this case actually teach us? Not what to think about affirmative action, but how to think about it. The majority is right that remedies should have endpoints. You can't use race forever and call it equality. The dissent is right that you can't declare color blindness in a society that has never been colorblind. Pretending the race is fair doesn't make it so. But the real question isn't who's right about the law. The real question is, has society caught up to what the law now demands? Are we ready for color blindness? Or has the court declared victory before the war is over? Or before the war is won? I don't have the answer. Neither does the court. But now you understand the question. You just read a Supreme Court opinion, not a summary, not someone's spin, the actual arguments. You followed the majority's reasoning. You understood the dissent's objection. You saw how two sides can read the same Constitution and reach opposite conclusions. You don't need a law degree. You don't need a lawyer to translate. You read the source material yourself, and you engaged with questions the court itself avoided. That's what this podcast is about. Not telling you what to think about the Supreme Court, giving you the tools to think for yourself. Every case I cover, we'll do this together. Read the majority, read the dissent, understand both sides, ask the questions no one else is asking. Then you decide who got it right. Because in a democracy, that's your job. Not the lawyer's job, not the pundit's job, yours. Next week, I want to tell you a story. It's about a father who loved his daughter, a caseworker trying to protect a child, and a system that punished someone for following rules they never learned were wrong. It's one case, but it's a pattern I saw repeated hundreds of times in 15 years as a court interpreter. And it teaches us something crucial about justice, legitimacy, and what happens when protection becomes punishment. Because before you can judge whether a system is fair, you have to see what it does to real people. I'm Mucho Belinda. This is The Third Voice. Thank you for watching. I'll see you next week.